What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Wednesday, January 22nd. Hope you guys have had a good week so far. I've just taken a couple of days to do some things around the house, hang out with my family, but we are back and we are going to catch up on some of the cases that we're following. I'd originally planned to start the recap of the preliminary hearing in the Matthew Rastelli case today, but I decided to just stay current with some of the cases that we're following, and I will get around to recapping that preliminary hearing most likely next week. What are we talking about today? Well, first off, we're going to talk about former Sheriff Mickey Stines. Then we'll move to Arizona and talk about Lori Vallow Daybell. And we will finish up talking about Bryan Kohberger. He has a hearing that's starting tomorrow at 11 a.m. Eastern. That is going to carry into Friday, and I will be live streaming both days on my YouTube channel. So come join us. It's going to be a bit different, and the stream may come off and on depending on what they're arguing, and we'll talk about why at the end of the episode. First off, Sheriff Mickey Stines, he shot and killed Judge Kevin Mullins in his chambers. He had a status conference Friday of last week where he appeared remotely. The prosecution talked about the huge amount of discovery in the case, saying it could take up to 4 to 6 months to complete any testing of the evidence and to complete the discovery process as a whole. His attorneys say they plan to ask that former Sheriff Stines be allowed out on bond at a future hearing that's not scheduled at this time. That issue has been in limbo until the appointment of the judge in the case. They're also asking the judge to order a competency evaluation for Stines. Now, the judge did not rule on that. He did take the issue under advisement. His attorneys also filed an affidavit saying that Stines is indigent. Now, last month, News Nation reported that Stines and his wife had some kind of a dispute the night before the shooting, and the source said the former sheriff was in a great deal of distress. They also reported that while at lunch together just before the shooting, Stines tried to talk to the judge about something that was said to be sensitive in nature, and the judge told Stines to come talk to him in his chambers. Just a reminder, Stines faces the death penalty if found guilty. Moving on to Arizona for Lori Vallow. She's asking to dismiss the case, which is conspiracy to commit murder against her ex-nephew-in-law, Brandon Boudreaux. Let's read through this filing. It says the defendant, Lori Daybell, requests this court to dismiss the case with prejudice. The facts. Number 1, the defendant was extradited from Idaho on November 30th. She put 2025. It was 2023. Number 2, the defendant was arraigned for 2 separate charges on December 7th, 2023. Number 3, a trial date was set at that time for a speedy trial on April 1st, 2024. And she put in parentheses, a speedy trial must commence within 150 days. Number 4, the judge deemed these charges complex, which gave the state 270 days to give the defendant a speedy trial. Number 5, the new trial date was set for August 1st, 2024, with the last possible day to begin trial September 2nd, 2024, to be in compliance with a speedy trial within 270 days. Number 6, the former defense team filed a motion for continuance, which the defendant objected to on the record, but it was granted, and a new trial date was set for February 24th, 2025. Number 7, a Rule 11 was also filed by former defense team, further delaying the trial, and a new trial date of March 31st, 2025 was set. Number 8, it has now been 314 days since the defendant was arraigned. She has 314 days underlined. Number 9, on January 10th, 2025, the judge declined to set a trial date for Brandon's case. Number 10, the trial date that is set on March 31st, 2025 is for Charles Vallow only. She is only in all caps, underlined, and there is an exclamation point. It is the position of the defense that no trial date has ever been set for the Boudreaux case. This alleged crime occurred over 5 years ago. The state of Arizona has had plenty of time to figure this out. At no time has the state ever been willing to combine these 2 charges into one trial. The state has maintained from the beginning that there will be 2 separate trials with 2 separate juries. The next section, she has number 1A. Therefore, why did they not schedule 2 trials at the arraignment? B. Why did the state arraign the defendant for both cases on the same day, knowing they could not provide 2 separate speedy trials? C. The state has had 5 years to figure this out. D. If the state would have arraigned the defendant on one charge and then arraigned the defendant on the second charge 1 month later, then 2 speedy trials could have been maintained. The state failed to do so. By March 31st, 2025, it will have been 394 days since the defendant was arraigned. The defendant has never waived her right to a speedy trial. Never is in all caps and underlined. The next section, the Sixth Amendment declares, in all criminal prosecutions, the accused shall enjoy the right to a speedy trial and public trial. In the state of Arizona, the designated speedy trial is to be within 150 days of arraignment. If the case is deemed complex, then the date of a speedy trial is extended to 270 days from the arraignment. No trial has ever been scheduled for the Boudreaux case. Therefore, the defendant's constitutional rights have been completely violated by the state of Arizona. The only remedy to this violation of this defendant's constitutional right to a speedy trial is to dismiss the case with prejudice. At no time has a trial even been scheduled for the case. The defendant's constitutional rights have been violated. The government must follow its own rules. And in all caps, she has an evidentiary hearing is requested. This is dated January 8th of this year, and she signed it Vallow Daybell. Moving on to Bryan Kohberger. The judge is not allowing the public inside the courtroom, and the judge will revert to sealed proceedings off and on throughout the 2-day hearing. Here's what the order governing procedures for the hearing beginning tomorrow and going through Friday said. It starts at 11 Eastern tomorrow, and at the start, the court will take testimony related to the motion to suppress the genetic information. The defense wants the judge to prevent the use of Bryan Kohberger's genetic information, which is really critical to the prosecution in their case. The motion was filed under seal, but his attorney said that Kohberger's Fourth Amendment rights against unreasonable search and seizure was violated when the FBI used investigative genetic genealogy by using public ancestry websites to close in on Kohberger. They say the subsequent search warrants and the product of those search warrants should also be tossed out due to infringing on his constitutional rights with the genetic genealogy that ultimately led investigators to Bryan Kohberger. There's also a defense motion for a Franks hearing regarding that genetic information. Let's just remind what a Franks hearing is. It's a court proceeding where the court is asked to determine if police or investigators lied in order to obtain a search warrant. What is the defense asking to suppress? Well, first off, they're asking to suppress that DNA evidence, every item seized from his college apartment, his car, as well as his parents' home in Pennsylvania, and all the information from his cell phone and online footprint obtained through search warrants, and anything obtained from the 2 search warrants for Kohberger's person when he was locked up in Pennsylvania and also when he was brought to Idaho to await trial. In court filings, his defense attorneys say that detectives working the case intentionally or recklessly omitted certain details from the investigation in order to convince a judge there's enough probable cause to obtain those search warrants. Now, his attorneys wanted the hearing to be public, saying sealing a suppression hearing was a violation of his right to a public trial. They say the reason is to combat what they say is an overwhelming public sentiment of his guilt. But the judge decided these arguments will be off camera. So if you join the live stream tomorrow and it is not live, just know that part of the proceedings have been cut off by the judge and are under seal, but we will certainly carry every minute that is live and available for us to watch. So again, 11 a.m. tomorrow, come join us. And depending on how long these arguments are, I may wait till Friday to recap both days, but we'll see what unfolds tomorrow. So that's it for today. I hope you guys have a good rest of your evening, and we will see you soon.